Good morning, everyone. I am Don Bautista, the Executive Director of AC Friends of Court. We assist British Columbians in completing legal forms. And these days, in a virtual setting. What we're noticing in our client intake calls is the palpable increase in stress from self-represented litigants because of COVID-19. And we have this sense that oftentimes the public doesn't really get a chance to see or hear what the heads of tribunals and courts are doing. And so this series allows them to speak unfiltered. And so what we're hoping to do this morning is to do three things with our guest. The first is to allow them to inform the public of their planning and the thinking behind their planning. Secondly, to tell the public how they're working to even the playing field. And lastly, to share their reflections on what they're learning now that might be important to continue after the pandemic. Our guest today is the chair of the Labor Relations Board, Jacqueline Aguayo. She's agreed to come on board to tell you what they've been up to and to assure you that even if they appeared before their board, that you can do so as you are without necessarily needing a lawyer to be with you. On that note, good morning, Jackie.
Good morning.
And welcome. And before I ask you the four questions, I'd like to give you the opportunity to just address the public. If there's anything you want to say at the offset, please go ahead.
Great. First of all, a very big thank you to AC Friends of the Court for inviting me to come and talk to all of you today. This is a really important initiative, and it's a very important conversation, particularly given a lot of the stresses that we're all feeling from readjusting to COVID-19 and the pandemic and the changes it's had on our work and personal lives. So as Don said, I'm the chair of the Labor Relations Board of British Columbia. I'm also the chair of the Employment Standards Tribunal. So I thought I'd start by giving you a very brief overview of what the two tribunals do for the public. So the Labor Relations Board itself is established under the Labor Relations Code, and it deals with all unionized workplaces in the province of BC. It addresses how unions get certified, how employees exercise that right of choice. It also deals with unions' duty of fair representation to employees, collective bargaining, essential services, strikes, and lockouts. And we deal with applications and complaints that may have a hearing element. We may mediate, we may engage in settlement conferences. So we interact in person with individuals in a number of different ways. We also hear appeals of our decisions. So we're both a first instance tribunal and an appeal tribunal built into one. And about 20% of the cases that we run involve self-represented litigants. So access to justice for individuals, members of the public, is a very important part of our mandate. And for the Employment Standards Tribunal, we hear appeals from the Director of Employment Standards. And of course, that director issues decisions under the Employment Standards Act, which sets all of the minimum standards for the employment of persons across the province of British Columbia. So as you can imagine, these are often very important claims to the individuals that are bringing them and to the employers that are often responding to them. And almost all of the cases that we hear at the tribunal, so it's appeals and reconsideration applications, are involving one or more, often many, self-represented litigants. And so that's the setting in which both the board and the tribunal operate, and hopefully we'll get you more information about what we do in response to the questions that Don has prepared for us today.
All right. On that note, Jackie, my first question. It's only been 2 months. By any stretch of the imagination, a short 2 months, and yet much has had to be done to keep your office open.
Yes.
And what lessons have you learned? I'm curious, what have you and your officials learned in terms of how you should be able to continue with your responsibilities to the public given the challenges that we have?
Well, in many ways, we're still evaluating what some of those lessons are. We, like many other people, our world sort of turned upside down on a dime. And we've had to move very quickly to find ways to continue to deliver our services. We're designated as a critical service, so we have remained open throughout the pandemic, though we have closed ourselves down for now to in-person interactions. So all of our staff are working from home. We have pretty outdated hardware and software, so it was a significant challenge for both tribunals, but we did it. And I think we learned three key things. First, the experience reinforced how fundamental access to reliable technology is. It enhances how we deliver the services that we provide, but it also provides individuals with enhanced access to our services. And of course, and I think we'll talk about this a little bit more, it can't be the only solution to responding to the challenges of the pandemic. But we need to go back and assess thoughtfully how we can incorporate our mandate flexibly, securely, and fairly in the context of some of the restrictions that we have in place during the course of the pandemic. Second, in a lot of ways, the pandemic was a real opportunity. It forced us to reevaluate and frankly to reprioritize how we communicate and how we deliver the services that we deliver. And maybe most importantly, what it did is it pushed us out of our comfort zones. It made us question how we usually do things and ask ourselves if really that is the best way or the only way to actually deliver the services that we provide. And that is a really important benefit that we are going to carry forward into the future in terms of our service delivery. What it did is it did create a long list of things that we need to do, but it has created this chance now to improve the way that we provide services to employers, to unions, to employees and the public in what everyone is calling the new normal. And third, it's an opportunity for us, given all of the things that I've just mentioned, it's an opportunity for us to move forward on two key broader objectives that we have been implementing at the board and the tribunal. First of all, we've endorsed the Access to Justice Triple Aim. And what that does is it includes a commitment to improve the access to justice for members of the public and to improve their user experience, to give them a greater sense of control, agency in their interactions with us at the board and the tribunal. We also need to develop what is called a trauma-informed approach to our service delivery. So for example, we need to look at our processes and we need to see if they further some important principles such as safety, choice, and control for individuals accessing the services that we provide to them. And these principles are more critical now, I think, than ever as people feel isolated from each other and we're all dealing with those kinds of stresses. And add to that, that participation in any legal proceeding, even for those that are familiar with our particular corner of the administrative justice system, it is overwhelming for many people and even more so now. So the pandemic has put real pressure on us to implement change in a way that is consistent with those broader principles and is sensitive to the circumstances that individuals find themselves in right now. And, you know, at the end of the day, that's a good thing.
Thank you, Jackie. It's interesting that maybe it's because we interviewed Minister Eby just before we did interview you. He too talked about stopping on a dime.
Yeah.
So it must be the phrase of the day, but he said to me, Dom, maybe it's more like a toonie than a dime. But the point is very well taken. We too are signatories to the Triple Aim, and I'm heartened to know that so are you. Being client-centric, I guess, for sort of typical institutions is not necessarily something that they would necessarily say it's important, because like it or not, if you've got business, you've got to come to, say, the LRB. Why is being client-centric important?
Well, it adds to the overall confidence that the public has in the system. If you think about the administrative justice sector, tribunals like the board and the Employment Standards Tribunal, the whole reason that they were created was to provide a much more user-friendly, accessible, timely, flexible way for members of the public to be able to access services and to have disputes resolved on matters that are incredibly important to them, that affect their daily lives. And so a public focused process, and you can define your public in a number of different ways, whether it's ensuring that the public generally, media, other institutions understand that how you do your work and how you're delivering on the mandate that you've been provided by government. The public also involves the individual constituencies that tribunals provide services to. So for us, part of being accessible and transparent allows employers, unions, employees, for both the board and the Employment Standards Tribunal to see the work that we're doing and to create a dialogue to help improve how we provide those services. So it's important for many, many reasons.
Technology, of course, should not be a hurdle. And there are two groups that we assist significantly. Those who don't have access or are not able to use computers. And I remember, I remember one specific client who relied on their being able to walk into the Surrey public libraries where we hold service because they had a Section 12. These days, with public intermediaries like libraries and community centers being closed, clients like that particular person have no access to computers. How can they transact business with you?
Such a good question. You know, access to technology means that many tribunals, the board and the Employment Standards Tribunal included, focus on getting information to the public through websites and electronic means. And given the pandemic, that has only increased because that kind of personal in-person interaction is inconsistent with the measures we need to take in order to flatten the curve. But some of the benefits of technology are that they increase in many ways and facilitate access. For those who don't live in Vancouver, for example, who can't just drop in, it decreases travel. Think of the benefits of on the environment. It decreases cost, it decreases time. But having said that, we really will continue to focus and emphasize a range of options that people can use to access our services and to get information from us. So for example, we have a general reception number. So let's assume soon in-person proceedings will start to begin. We have a general reception number that people can contact. We often find that individuals don't really know where they need to go to resolve their problems. So we have a whole list of numbers and we try to redirect people and we try to bring them into the fold if it looks like it's something that is covered, for example, under the Labor Relations Code. The board also has an information officer who individuals can access either by phone or by email. And the information officer's mandate in part is to provide information to individuals to help them navigate our processes so that they can understand what to expect when they're dealing with the board. We also, when our reception area is open, which we anticipate will start reopening in July, we have drop-in. So people can drop in. We'll try to make a staff person available. They'll come upstairs, they'll talk to an individual, and they will try to help them navigate how we can help them, if we can help them, and if we can't help them, we provide them with contact information for other organizations. We also have a whole range of ways people can file their applications. They can drop it off, they can do it by fax, they can do it by email. We're developing e-forms, but you know, that's technology. So if you don't have a computer, an e-form is not particularly helpful to you, nor is an email. We also, when we get applications and complaints filed, we look at them, and if they're incomplete or if it seems unclear what the individual is applying for, so let's assume they haven't reached out to us first before filing, they just file. Our information officer or our deputy registrar will get in contact with them and reach out, and they'll explain what we need and why we need it and give them an opportunity to refile. So of course, this isn't strategic advice, it's not legal advice, but it's an important opportunity to interact with members of the public so they can better understand our processes. And in a lot of ways, we learn from that, because if we keep getting the same questions that people don't understand about our process, then we can reevaluate how that process functions or how we're explaining it to people so that we can cover off some of those bumps. So that's where we're at now.
Thank you. Of course, there's the other group that's near and dear to our hearts, are those victims of gendered violence. I remember sort of taking phone duties 2 weeks ago, and a woman and I had an appointment, and she says to me, I can only speak to you up to this time because my partner will be awake soon and I have no private space. This is as best as I can do. I cannot leave the house, but I have issues. And in her particular case, it had something to do with going to work. And so I said, well, what are we going to do? And of course, within AC, we know self-reps are out there. But during pandemic times, we also know that they're nowhere to be found. So at some point, when things go back to, as you call it, the new normal, victims of gender violence will start appearing before you and your board and your tribunal. Are you making sort of special arrangements given our conversation about being client-centric and being able to deliver in a trauma-informed way the services that you make available to your clients?
Well, that's one of the important challenges that a trauma-centered approach requires us to evaluate how accessible we are. Generally, at the board and the tribunal, we tend to have relied on individuals or their representatives, if they have one, whether it's a lawyer or an individual, to let us know what measures we can put in place to assist them in feeling safe. And that's either because they're attending in person or because they're giving us information that is incredibly sensitive and personal. And so we want to make sure that those who are vulnerable have access to our services, and that we do it in a way that keeps the processes fair and flexible and proportional for everybody. To the extent we can achieve that safety, and build in a trauma-informed approach using online tools as well. Things like reaching out, setting up a time, if you're in a proceeding together, making sure that you have a virtual breakout room where if that person is experiencing stress or anxiety, we can pause a proceeding, they can go into a very private space and have a moment to recalibrate. We can set up timing. That the administrative justice system is incredibly flexible, and it should be flexible for individuals who have experienced trauma or are under threat of domestic or other forms of violence. So we do try to build those things into our systems. One of the other things that we have is a privacy policy that allows individuals to identify whether they are in a personal situation where, for example, we may not publish their name or other potential identifying information, because if there's a restraining order from a former domestic partner, etc., we need to take those things into account and not just publish decisions that might indicate where the individual works or what their personal circumstances are. So we do try to build all of those measures in, and I think the benefit of a trauma-informed approach going forward is that we can continue to ask ourselves, are we doing enough for individuals who are subject to all forms of violence, including gendered violence?
Thank you for that. You mentioned the word hour, H-O-U-R. Pre-COVID, what were the hours of operation for hearings?
Well, we try to be flexible too. Given, for example, at the board, given that we do illegal strikes and lockouts in essential services, our hours could be any time, any day of the week. Generally, our hours were about 8:30 to 4:30. Now, things are different when you're in the electronic universe. Our hours of work really are only critical for when we deem an application to have been filed. The rest of it, we seem to be We seem to be working all the time.
Well, okay, yes, because my favorite word these days is because it's something that we certainly practice is asynchronous.
Yes.
We recognize that work is not sort of the industrial age version anymore, that people work in different times, different days of the week. And so we are heartened that both the tribunal and the board sort of have that flexibility. And I'm hoping that post-pandemic, that you would consider that service not so much as a sort of a tweak given the times, but a reason to transition to a more defined asynchronous type of service where as long as the parties can agree to what is a reasonable time, that you can do your business.
Yeah.
Now, going to my third question, cases being urgent and non-urgent is the question. And there was a lot of talk because our friends in the courthouse, given their limitations, many of which were valid, had no choice but to react in terms of designating whether a case would be seen as urgent or non-urgent. What has your experience been?
Yeah, it's for us, urgency sort of has some context. So let me explain what I mean by that. The first thing is that we need to have a process that's, as I keep saying, fair to everyone. An individual is only one participant in a dispute. So that doesn't necessarily, fairness doesn't necessarily mean the same thing for everybody who's involved in a proceeding, and an individual's own sense of the urgency of their matter may not actually align with what they feel they need to or are willing to do to pursue their claim. People understandably want things to get moving incredibly quickly, but of course, as tribunals, we're balancing a fairly heavy workload. At the board, a lot of the cases that we deal with are urgent simply by virtue of the legislation that we operate under. So, for example, if individual employees are applying to decertify a union, for example, we have to do a vote on that in 5 business days. So we're talking about pretty tight timelines, but generally the Labor Relations Board's decisions are issued within 180 days of the date an application is filed, which is 6 months. That is, for someone who wants their matter to proceed quickly, still may seem like a long time. We generally try to get our decisions out well before that, but we have up to 180 days with some exceptions. For the Employment Standards Tribunal, where most, if not all the appeals involve one or more self-represented litigants, we know people want an answer quickly, and we're talking about minimum employment standards here. So we generally get our decisions out within a month or two. So we're relatively quick and nimble in terms of how we deliver our services. I think that, you know, it's a more of a seismic culture change, I think, for the courts. And, you know, there was that decision, Pintea, that talked about how you provide, information and assistance to self-represented litigants where you can see that they're making strategic decisions that may be absolutely contrary to their interests, and they may not know, you know, what they're doing, what the consequences are of what they're doing. But the board and the tribunal and a lot of administrative justice sector have a long history of building assistance into their mandates and their structure. So we're very lucky in that way. You know, it's important for people to know what to expect and what's expected of them, and all of those things drive people's sense of urgency and how quickly they can expect to get an answer. And I find that more often than not, if you explain to people, this is what the process looks like. You're going to file your application. We're going to look at it. Someone has got to provide a response, because that's the only way at the end of the day for a decision to have any credibility and finality. So once people understand how the process is going to roll out, they can then sort of calibrate their desire to have an outcome based on what the consequences and the processes are going to be. So.
Thank you for that. That leads me to my fourth question.
Yeah.
Earlier on, you said, okay, at the board level, 20% are self-reps. 80%, I presume, are represented by labor lawyers and the like. And so that makes lawyers very, very powerful insiders. They tend to specialize in labor law or employment standard issues that they've acquired expertise. And because of that, they, through their bar associations, have subsection practices. Through our regulator, they have a pipeline to the board and the tribunal to talk about these things. And it's become apparent during the pandemic how a lot of this collaborative work, of course it was necessary, made communication much easier. But for someone who is unrepresented, how do they reach out to the board? How do they reach out to the tribunal so that they can feel a connection? And if there were things that they wanted to tell you and your staff, how do you suppose they can do this?
Such an important question. For the board and the tribunal, for example, we're the only place individuals can go to get a decision on an issue that's covered by the code, or an appeal against a decision of the director of the Employment Standards Branch. So we know that the workplace, employment, they play very important roles in our lives. And the courts have long recognized that work, a sense of participation in and control over your workplace are critical to your sense of self-worth, to individuals' sense of dignity. And we may spend more time at work than we do with our friends, with our families. And in the pandemic, those two worlds have now collided and added an additional layer of stress for those who have been working from home, and in different ways for those critical workers who are out there working so diligently to keep our province open and to keep the services running for the public. So, I've described some of the ways that people can connect with us already. We're lucky at the board in particular because we do have an expert and engaged labor bar in British Columbia. Mm-hmm. But we are also dealing often with experienced employer representatives and union representatives who are not lawyers technically, though they do have expertise in the area because that's their role. We can always do better. So part of the key to your question is, how do we do better if we're not communicating or having a dialogue with individual self-represented litigants? And I talked a little bit about how we reevaluate questions that we get where people seem to be having the same problem with certain parts of our process or our requirements, so we reevaluate. We do have a few projects on the go which include revamping our website and making it more readable and intuitive and accessible and informative, and creating a communication feed where people can give us feedback. What's working for you, what's not working for you, so that we can constantly engage in that process of reevaluation. We're also in the process of rewriting all of our information to use plain language. Part of the pipeline that lawyers have, and I'm a lawyer, I know how difficult it is to move out from using terms of art that we all are familiar with, whether they be Latin or not, and to try to stop using those terms and come up with plain language equivalents so that everybody can feel like they're part of the process. So we want to also translate materials so that individuals who are not English speaking or who are not comfortable with English are able to have access to information so that they can interact with us on a more effective level. So in the end, our approach is that the work of the board, the work of the tribunal, it's not ours to shape in a way that works for us. both tribunals offer a public service. And so it's one that is intended to provide flexible, timely access to justice for unions, for employers, for employees across the province. And so we always have to keep our eyes on that prize and make sure that we're constantly reevaluating in some of the ways that I've already described. It's a long list of obligations, I think, that we have to take on, but it's a very important one and one that we're absolutely committed to for the future.
Well, thank you for that, Jackie. I have to say, I was thinking whether I would even raise the question of plain language, but you took the words out of my mouth. So thank you. I can tell you from our perspective, ever since we opened our first service evening on February 8, 2011, of the top 3 areas of law that we've had to assist in, employment's always been there. And, you know, I say, once people start moving their attention towards their legal affairs, they've kind of pushed down because there were more important things to do. We're having to gear up because we know that employment these days, there are going to be issues already that will be coming to the forefront. And I'm glad we've had this discussion because I know that when we spoke, we corresponded by email. I said there's going to be things that we're going to be doing in the future. And it solidified my view that post-pandemic, there's still going to be work. There's going to be a huge demand for workplace issues. And I'm heartened by what you said. And so, like all my interviewees, I'd like to give you the opportunity for final comments to the public who've been listening to you this morning. If there's anything else you want to say, now's the time.
Now's the time. I think ultimately what is important to all of us at the tribunal and at the board and to me as chair is to ensure that the work that we do is for the constituents we serve. The tribunal and the board are not ours. They are, you know, there to provide service. And those services, as I described, the importance of the workplace and work to individuals, these services are incredibly important to British Columbians. And I think it is our obligation to continuously ask ourselves how we can do better. And how we can do better, not from our own perspective and our own experiences, but to try to broaden the range of voices that are helping us to inform and improve the services that we provide. So I think that at the end of the day, this opportunity that you have given us through AC Friends of the Court to answer these really important questions and to begin a dialogue is the road to the future. And the pandemic is one of those very difficult but important moments in which we have been forced to actually put some of these things into practice. They are very important ideas that we talk about as intellectual ideas in many cases, and the pandemic has really shown us how important it is to not just talk about it, but to actually do it. And so I'm really looking forward to continuing to work with you and other organizations and to continuously improve and change how we do what we do.
Well, you've certainly made me a much more informed person as far as the work that we do. I look forward to working together with you. On that note, I wanted to thank you and wish you well. Please stay safe. I wish your colleagues the same, and we will see you soon.
You will indeed. Thank you very much.
Have a wonderful day, Jackie.
You as well.
Bye-bye for now.
Bye-bye for now.